The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to today's Law of Self-Defense members only content. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Today I'd like to share with you the motion filed today by attorney Eric Nelson, defense counsel for Derek Chauvin, seeking a new trial for Chauvin on a variety of grounds. That motion is embedded in the text version of today's content. The motion for a new trial for Chauvin is based on a number of specified grounds and also explicitly notes that these are not the exclusive grounds justifying a new trial. Among the grounds enumerated are the failure of the court to allow a change of venue, the failure of the court to recognize that pre-trial publicity made a fair trial impossible, the failure of the court to sequester the jury for the duration of the trial, the state's pervasive prosecutorial misconduct, the failure of the court to order Floyd's purported drug dealer, Maurice Hall, who was present with Floyd at the time of his arrest, to compel him to testify, the claim that the court improperly instructed the jury on second-degree unintentional murder, the failure of the court to prevent the state from presenting prejudicial cumulative evidence, the failure of the court to prevent the state's leading questioning of their witnesses, the failure of the court to not require a record to be made of the many sidebars that occurred during the trial. Further, the defense moved for what's called a Schwartz hearing, where the verdict could be impeached. In other words, shown to be invalid on the grounds of jury misconduct. This hearing would involve direct questioning of the jurors. Usually the questioning is done by the judge with defense counsel and prosecutors in attendance, but defense counsel and prosecutors don't directly participate in the questioning. Presumably, this jury misconduct claim is based upon recent revelations that juror number 52, Brandon Mitchell, concealed his activist impartiality, including participation at George Floyd protest, from the court during his voir dire, or jury selection. That's about all we really know at the moment, folks, but you can be sure I'll keep the law of self-defense community informed as things progress, and I'll address many of the grounds cited in this motion, again, embedded in the text version of today's content. I'll address many of those issues, especially the jury misconduct issue, in a more comprehensive post, video, and podcast tomorrow. Until then, remember, you carry a gun so you're hard to kill. That's why I carry a gun, so I'm hard to kill. My family is hard to kill. Make sure you also know the law so you're hard to convict. All right, folks, until tomorrow, I'm Attorney Andrew Branca with Law of Self-Defense. Stay safe.